Assalamualaikum friends, hope you are all doing good. सब अच्छे होंगे, मज़े में होंगे. Today we are in lecture 2 of Indian Penal Code and we are going to discuss the jurisdiction of criminal codes. In lecture first I have given you the brief overview of the Indian Penal Code and I have discussed with you in that lecture that chapter 1st, 2nd and 3rd of Indian Penal Code deals with introductory provisions. Today we are going to discuss the chapter 1st of Indian Penal Code and now coming to first of all, now let us begin and now first discuss this section first, which deals with the title and extent of operation of code. And it says that this act shall be called the Indian Penal Code and it shall extend to the whole of India. Previously, there was one exception to this section, that was that this code shall not apply to the state of Jammu and Kashmir, because the state of Jammu and Kashmir was having its own code, Ranbir Penal Code, but due to the abrogation of Article 370, that has now been repealed, and now the Indian Penal Code equally applies on the UT of Jammu and Kashmir. Now coming to jurisdiction of criminal courts, section 2 to 4 lays down the jurisdiction of criminal courts. Section 2 talks about the punishment of offense committed within India, and Section 3 talks about punishment of offense committed beyond India. Section 4 talks about extension of code to extraterritorial offenses. Keeping in view all these three provisions, we can come to this conclusion that jurisdiction of criminal code can be classified into these following heads. First one is personal jurisdiction, second one is territorial jurisdiction. Territorial jurisdiction can again be classified into intra-territorial jurisdiction and extraterritorial jurisdiction, and third one is admiralty jurisdiction. What is personal jurisdiction? Personal jurisdiction means section 2 says about talks about personal jurisdiction. I will not read here the section language of section 2. I hope you will look that from Bear Act, but keep that Bear Act with you, and I will summarize the section 2. I will try to summarize section 2. What section 2 says? It says that every person shall be liable to punishment, ठीक है, for every act or omission contrary to the provisions thereof, of which he shall be guilty within India. It says every person. It is not talking about only citizens. Section 2 is talking about both Indians as well as foreigners, and every person is liable, whatever be his rank, whatever be his nationality, whatever be his caste, he shall be liable to of punishment if he is found that he has committed an offense within the territorial limits of India. So it is known as personal jurisdiction, or we can say intra-territorial jurisdiction. But there are some exceptions. The exceptions are that there are some persons who are always exempted from the jurisdiction of criminal courts, and these persons are foreign sovereigns, ambassadors, alien enemies, foreign army, warships, and presidents and governors. Why are these persons exempted from the jurisdiction of criminal courts? Because these persons enjoy certain rights and privileges conferred on them by the government, so they can't be held liable, they can't be punished, they are exempted from the jurisdiction of criminal courts. Now coming to territorial jurisdiction, section 3 and 4 talks about the territorial jurisdiction. Territorial jurisdiction means the power of a state to exercise jurisdiction throughout its territory. But the territory of a state does not comprise only land, does not it comprise seas only, waters, or water, it comprises land, also it comprises sea, also it comprises airspace, also internal as well as external waters are also included in the territorial jurisdiction. Section 3 and 4 talks about the intra-territorial and extraterritorial jurisdiction. Section 2 talks about the intra-territorial jurisdiction, and section 3 and 4 talks about extraterritorial jurisdiction. Section 3 and 4 talks about extraterritorial jurisdiction. Extraterritorial jurisdiction means that if a person has committed an offense beyond the territorial limits of the state, he would be held, provisions of the code would be applicable on him. how the provisions, because section 3 and 4 talks about this. For example, if a person is a citizen of India and he committed a murder in Uganda, he can be tried and convicted of murder in any place in India in which he may be found. And section 3 talks about that any person liable by an Indian law to be tried for an offense committed beyond India shall be dealt with according to the provisions of this code. ठीक है. And section 4 talks about the extension of code to extraterritorial offenses. That means it has now got clear that section 3 and 4 applies to extraterritorial jurisdiction. Section 3 and 4 deals with extraterritorial jurisdiction also. And section 4 talks about that the provisions of this code applies to any offense. If any citizen of India in any place commits any offense within and beyond India, provisions of this code will apply on him, because section 4 says. And second is any person on any ship or aircraft registered in India, wherever it may be, section 4 Indian penal code will apply also on him, because section 4 says. And section 4 also says that if any person in any place without and beyond India committing offense targeting and computer resource located in India, the Indian penal code will apply also on him. Though so section 3 and 4 are giving powers to the Indian courts to try those offenses also which are committed beyond the territorial limits of India. This type of jurisdiction, which has been conferred by the provisions of section 3 and 4 on the Indian criminal courts, this type of jurisdiction is known as extraterritorial jurisdiction. Now question arises, what is admiralty jurisdiction? Does our Indian courts can exercise admiralty jurisdiction? Does our courts have the power to exercise admiralty jurisdiction? Yes, the answer is yes. Our courts can exercise admiralty jurisdiction also. Admiralty, there are specific courts for it, those are known as admiralty courts, and they have power to deal with mercantile cases and maritime cases. They are meant for these types of cases only. And section 4 also confers power on the Indian court to exercise this jurisdiction. Okay. Section 4 of the code says that the Indian courts have power, Indian courts have jurisdiction over offense committed on Indian ships on the high seas. ठीक है. And they have power to try to have jurisdiction, they have power to extend their jurisdiction over offenses committed on foreign ships in Indian territorial waters, and they have jurisdiction to try the piracy related offenses. This is the section 4, which gives the Indian courts power to exercise admiralty jurisdiction. Question is, what are high seas? High seas means an open ocean. It's a type of open ocean. They especially belong to no one. They are known as res nullius because no state has authority over those seas, and Indian courts have power to try those offenses also if they have been committed on the high seas. Okay. And now coming to section 5, section 5 excludes the jurisdiction of courts, excludes the jurisdiction of Indian Penal Code. And what does it mean? It means that it excludes jurisdiction of the code from dealing with mutiny and desertion of officers, soldiers, sailors, or airmen in the service of Government of India. It particularly applies to the soldiers, sailors, airmen, because they are having their own law that is known as martial law. They can't be tried. Provisions of Indian Penal Code cannot be made applicable on them. They have their own provisions. So it can be asked in exam that which provision excludes the jurisdiction of the code. That is section 5 of Indian Penal Code. That is all for today's lecture. Hope you would like my lecture, enjoy my lecture. If you like my lecture for any reason, hit like button and subscribe my channel. Don't forget to share with others. Don't forget to comment on my lecture. Have a nice day. Enjoy your day. Allah Hafiz.